Alright, welcome to another video for Grade 12 Law. Today we're going to look at some of the historical influences that have influenced our Canadian legal system, how they got there, some of the theories behind that, and some of the philosophies that have been part of building our particular legal system. So what we want to look at today is the fact that we're not totally sure where all of our laws and our legal system comes from because there are influences from all different types of things, everything from French law to British law to Aboriginal law and all types of other stuff in between. So we want to talk a bit about the different theories that have influenced the development of law in general, as well as what leads us to our Canadian legal system. So a lot of the stuff that we're going to talk about speaks about the nature of law and this idea of natural law, which we have looked into, and we'll talk a little bit more about that, but also some things like divine law, which we haven't really introduced, and then go back to, say, positive law, which we've also talked a bit about. So for some of these, it looks to us like maybe they can stand on their own, but it makes way more sense if you think that they're all part of the creation of what law is. So with divine law, you're looking at this idea that divine law comes from the Word of God. And so we can look at legal systems around the world. There are still many that follow this idea that the legal system and law itself should be based on what God has told you, whether that's your particular faith or whether that's a particular type of religious system. It depends on sort of where you are in the world, but there are lots of legal systems that are built on this idea. So this idea is that this philosophy of law rests solely on the basis that law is the belief of divine intervention, which of course means that all laws come from God. So if you want some examples, things like the Ten Commandments, if you're familiar with the Christian faith, this idea that God handed down 10 rules for which people needed to live by. The Code of Hammurabi is one that we'll talk a bit more about. It's this idea that God spoke directly to Hammurabi as the ruler and gave him this power to come up with some of these rules and some of this idea. Also examples of things like in the Quran. So if you're of the Muslim faith, there are different types of law and different types of legal theories that are associated with religious doctrine. So again, this is a basis for all kinds of faiths in all kinds of places around the world where there are elements of divine law that influence what our legal systems are, and particularly we see this again in Canada and much like many other places. So just to go back to this one, because the Code of Hammurabi is very important, maybe you've heard of this one before. This is one of the very earliest legal codes, and it's important because we use the term codified, as in it was written down. It was all carved into these giant stone sculptures. And one of the things that the Code of Hammurabi is very famous for is this idea that it's very severe punishment. So this idea that you would be punished for an eye for an eye. So if you blind somebody, they would be entitled to blind you as well. So while this is a very harsh and severe punishment, sometimes it also depends on status. So there are elements of bias in this, in that the wealthier people or the more powerful people would get a lesser punishment. So that's something to be said for the inequality of the Code of Hammurabi. And this is also this idea that the state could intervene and resolve disputes. This is one of the main sort of important features of this Code of Hammurabi. A, that it was written down and codified so that everybody could see it, even though, again, parts of it were unfair and unequal, but this idea that the state could intervene and resolve your disputes, whereas before, two people had an argument, they would settle it themselves. Well, now it was the state and the government's job to do some of that for you. Under Roman law, we had this idea that the law regulates all aspects of your daily life. And what the Romans did is they developed the 12 tables. And the 12 tables brought together a bunch of these common laws that were throughout the Roman Empire. And they collected them and codified them again into this thing that where people could see them and people could understand them and people could participate in law and understand the overall effect that law has on society. With this one, we're talking about the fact that the lower classes thought that the unwritten laws, the sort of customary laws that had been around, they really favored the wealthy. So they protested against this and forced the development of the 12 tables as part of this idea of logic in the law. You also see some things like the Justinian Code, which had a massive influence on the law and on the legal structure of Roman law. So in 529, the Roman emperor, who was Justinian at the time, he created this code that becomes part of the basis of the legal systems of most European countries. So for example, this code made slavery against the law, some of the more major developments. And again, at the time, that's a pretty important development. Some 1,200 years later, so the French Emperor Napoleon Bonaparte, he commissioned a new code of laws called the Napoleonic Code, and a lot of it was based on the Justinian Code. So in Canada, we have the basis of a couple different legal systems, one of them being Aboriginal law. And a lot of the Aboriginal systems of the various nations that were in Canada before the Europeans arrived, there was all these different ideas of sort of how legal systems should work. And a lot of these nations would have different legal approaches and different legal systems. And a lot of them, of course, based on oral traditions that were just passed down verbally. So around 1450, you have the nations of the Mohawk, the Onondaga, the Seneca, the Oneida, and the Cayuga coming together to form the Iroquois Confederacy. And this was a pretty big deal because the Iroquois Confederacy wielded a great amount of power in the region at the time and became a very influential and important component of the North American history. So a lot of the laws that were covered under the Confederacy were this idea that there were same areas as other legal codes, a lot of the same type of stuff that you would see in some of the other major codes that we will take a look at. So what you would see under the Great Binding Law, which is what it was called, that the Iroquois Confederacy followed, was a lot of these same ideas, things like emigration, treason, secession, all these different rules and obligations that to be part of this Confederacy and to be part of this made you subject to these different laws. Another thing that some of these laws outlined were the ideas of equality, justice, and fairness that you wouldn't see until some later modern civil rights documents, which is a very interesting development. A lot of this also prevented the rise of internal hierarchy, and this idea that the Six Nations outlined historical reasons for conflict and addressed them. They actually talked about this idea. And one of the major sort of things you would see in the Aboriginal law and some of these Aboriginal laws is this idea of restorative justice. The idea that if somebody's been harmed, you work to rebuild that relationship and to amend what's been done wrong to them. So in Canada, you also have the influence, of course, of the French. The French follow what was called civil law. This is a legal term that means different things depending on its context, right? So part of it is that in discussion of systems of law, civil law refers to the type in which all laws are codified in statutes. So this idea that everything's written down and codified. So a lot of it's based off the French Civil Code, which we talked a bit about with Napoleon. He develops this in the early 1800s. In the civil law system, they would use the inquisitorial system rather than the adversarial. And we'll talk a bit about the differences between those a little bit later on. But this is one of the major differences. And Quebec still actually is allowed to use that because they were granted this right to use civil law under the Quebec Act of 1774. So Quebec has a slightly different legal system than the rest of Canada, which is somewhat strange. But, I mean, Quebec is a slightly different place. So, of course, they would have some different regulations. So another major influence, of course, for Canadian law is British common law. So under the present legal system in Canada, it's been influenced by several different legal systems as we've talked about, so different writings and legal codes, but the British probably have the most significant influence. William of Normandy conquered England in 1066. We won't go too far back, but 1066 far enough. He inherited this kingdom where it's already developed and there's already a developed system of law. However, it's very decentralized. It's all over the place. Different regions have different laws and different areas have different customs, and everything is a bit different geographically depending on where you are. So he decided he wanted to centralize this, and he set about developing some legal systems that would be more controlled. So this system of law applied to all of England. Slowly over time, this idea of common law developed and helped standardize law and justice. It didn't happen right away. He didn't come up with this sweeping movement, but as you start to centralize things and things become more consistent, common law gives way to this idea of sort of consistency. So the current English system of law came from Henry II. So he's the one who set up the system of traveling judges, and they were known as circuit judges, and they would travel around the country and they would solve disputes for people. And so this takes time again. They traveled a very specific route, visiting villages, hearing cases, and for the first little while it's very difficult for the king's judges to overcome local traditions and customs, but eventually decisions start to get written down and they start creating precedent and they start to follow precedent and it becomes common law. So common law in this instance has three meanings. It refers to the law that comes from Britain, it applies to all subjects of the land, and it also means that this is based on past decisions of judges. So those are the three sort of common uses of common law. One of the, of course, major differences we want to look at is this idea of adversarial versus inquisitorial. So the adversarial system is this idea that the burden of proof rests on the prosecution. So the judge controls the trial and makes sure both sides abide by the rules, but the judge doesn't really weigh in on a whole lot of stuff. So one side is against the other. And this theory is that if both sides are passionate about what they're doing, the truth will emerge from the two tellings of the story. Whereas the inquisitorial system is this idea that the accused must answer questions. Under the adversarial system, if you've been charged with a crime, you do not have to take the stand, you do not have to answer questions. That is your right. And under the inquisitorial system, you don't have that right. The judge has a lot of control on this idea that the impartial judge will seek out the truth and find that truth by questioning the accused and by making them answer questions. So it also comes from the British law that we trace a lot of the origins of our trial procedures and methods of determining guilt or innocence. So the determination of guilt or innocence was decided by divine intervention during the Middle Ages, and there's lots of examples of this type of thing where people believe that God would judge the guilt of the or the innocence of somebody, and various means were devised to reveal God's judgment. So part of the way that we do this is through things like trial by ordeal and trial by combat. And of course, we don't use these anymore, but these were very sort of in fashion at the time. So trial by ordeal is one of the ways that we would determine guilt or innocence, and this is basically make the accused undergo some kind of ordeal. So with this, the accused would be forced to hold his or her hand in scalding water, for example, or to grip a red-hot iron bar, and if the wound would then be bandaged and reopened after a predetermined number of days, if the wound was healing, it was a sign that God had judged the person innocent. If it was infected, the person was found guilty. So it was possible to dispute guilt by having a number of people swear an oath helpers, as they were called, as to the innocence of the accused, but obviously this method is not exactly perfect. You put the person through some sort of physical ordeal, and if they survive or they heal well, then God wants them to be healed, and therefore they are innocent. I mean, you can see some of the problems with this, but that's the system that a lot of places used, especially in medieval Europe at the time. You also have trial by combat. So, I mean, if you've seen Game of Thrones, you're probably familiar with this, but basically what would happen is that it was another way to determine innocence was for the accused to challenge the accuser to a duel. Now, again, this doesn't seem like the best way if we're looking back at it retrospectively, but at the time it made sense to people. So it was assumed that God would be on the side of the righteous party, and therefore the victor was presumed innocent. So if you were to challenge somebody to a duel and you won, then obviously you were innocent because God protected you and helped you win. If you look at trial by combat, though, it is sort of like the forerunner or the precursor to our own adversarial system. But instead of physical battle between two supposedly evenly matched adversaries, we now have sort of a mental battle, a battle of wits, if you will. So two parties have these legal professionals and who can go and argue for them, and it becomes sort of a combat. I mean, you can look at it that way if you wanted to. Eventually, though, once we determined that crime was not just an offense against an individual, but an offense against society or the state, it was decided necessary to create a new form of trial and a method for determining guilt or innocence. So for this, our modern court system finds its roots in three different court systems. The first was communal court. So communal courts were basically in small communities and usually administered by local people. The second court system consisted of the feudal or manorial tribunals. What would happen here is that in the feudal system, mostly in England, the last development was the royal court system. So initially the royal court system was set up to administer the collection of taxes through the court of the exchequer. Another type of court was the court of the chancery, where writs or commands in the name of the sovereign and summonses or calls to appear in the court were obtained. So basically this is the system whereby you were called to go to court based on the court of the chancery, and that was part of the system at the time. Other courts, we have this court of common pleas. I think I have that included there. Yes, we do. It was created to handle civil matters, but the grandest and sort of most expensive one, the most elaborate one, was the court of King's Bench. So this is the court that dealt with serious criminal cases and was made up of various nobles appointed by the king. And one of the things we see in the influence of this is that by the 13th century, most of the authority in the court system came from the crown, or in fact all the authority came from the crown. So today in all Commonwealth countries, including Canada, our judicial system, the authority lies with the crown or with the queen or the king or the monarch. So an offender commits an offense not only against the victim, but also against the crown. Hence, this is why we have the RV, whomever, right? So this is what we've talked a bit about before, but it's a representation of the crown.